Okay, well, good evening, everybody. Thank you for joining us this evening. My name is Des Hudson. I'm chair of the IFOA's Regulation Board, and I'm going to be chairing the event this evening. So, without further ado, let me start then by reminding you that this is an event which is giving you both general information about GDPR, but we're particularly trying to focus on the position of scheme actuaries faced with the challenges and the changes of GDPR. And I'm delighted to say that I'm joined this evening by Chris Green and by Martin Sloan. Let me introduce Martin first. Martin, I think, is an acknowledged expert on the question of data protection. He's a lawyer based at Brodie's Solicitors in Edinburgh. And he advises a whole range of diverse clients around issues of data, confidentiality, rights of privacy and so on and so forth, but in particular GDPR. And I know that he's involved in a whole host of advice around GDPR to a range of widely differing clients. And he's going to speak to us first, and he's going to set the context for the changes, and we're going to go through with Martin his assessment of what those key changes are and some of the big issues. And then we're going to go to Chris. Chris Green has some 25 years experience of actual work, most of those 25 years as a scheme actuary. And Chris is going to try and provide a context based upon Martin's presentation about the implications for scheme actuaries and what he and his firm are doing in terms of their general approach, as I say, as scheme actuaries. So as well as his own range of responsibilities for clients, for his firm, for LCP, he's involved in the appropriate work and project activity for that firm's preparations for GDPR. And I know, again, he'll refer to that by way of examples to illustrate some of the points that we're going to deal with. So I'm going to ask our two speakers to undertake their presentations. There are slides. There's no need to make copious notes because we will make those available on the website in due course. At the end of the presentations, our plan is to make this available for questions, and we're going to have about at least half an hour or so of time for questions. So start thinking of your questions. I prefer not to take questions during the presentations so we can try and better manage time, but we'll hopefully have quite a lot of time, as I say, to deal with your questions at the close of the event. I will make sure that we finish on time at 7 o'clock. And for those of you who can, I hope you'll be able to stay behind and join us for some refreshments, for a glass of wine at the end of what I think will have been a very interesting and stimulating presentation. So, without any further ado, Martin, can I ask you to kick us off, as it were?
Thanks, Des. For those of you who, I don't know if any of you watched the webinars that we did last week on GDPR through the IFOA website, but you'll be really clear that today's presentation is not just a simple rehash of that. What I tried to do today is focus more on scheme actuaries and what GDPR means for those. There'll be a bit of overlap in terms of some of the content, some of it you will have seen before if you watched those webinars, but a lot of it is focusing particularly on what it means for scheme actuaries and just looking at what your role is under data protection law and how GDPR impacts upon that. So what am I going to cover? Kick off just with a refresh on some data protection basics, so the terminology we use and what we're talking about. So you've got that familiar terminology. Then go on to look at scheme actuaries and data protection law and just a recap of the guidance that was issued a number of years ago now by the IFOA. And then go on to look at GDPR, what it is, what's changing, some of the key issues, talk you through those before finishing up for my section with a little bit about preparing for GDPR and some of the sort of the key things I think that you as scheme actuaries will want to be looking at if you're not already doing so over the next couple of months. So just starting with some data protection basics. So the current law that we have is based on 1995 EU directive, and that was implemented in the UK by the Data Protection Act 1998. And it applies to controllers who process data that is what we call personal data. So let's break that down. So the controller is the entity, and it could be an individual, it could be a company, it could be a partnership, whatever it may be, that determines the purpose and means of processing of personal data. So it is the one that's the decision maker, decides what is done, how it is processed, makes those decisions. If you're processing on the instruction of someone else, then you are what we call a processor. And you have different rights and responsibilities. At the moment under law, you have no direct responsibilities under data protection law. That changes under GDPR. If you're an employee of a controller, then you're not a processor, you're just doing something in the name of the controller. And processing is anything that you do with personal data. So even having a file, sticking it in a filing cabinet and not doing anything with it for 10, 15 years is processing. So the simple fact you hold it is processing, and that is regulated by data protection law. And personal data is any information which relates to a living individual. So once someone is dead, data protection law doesn't apply to data about them, but for as long as someone is alive, data protection law will apply to any information that relates to them and can be used to identify them. And it's a very broad definition in terms of what that can cover. It's not just names and addresses, it's any other identifier where you can identify a particular individual, even down to things like photos or unique reference numbers, customer numbers, if you can match that to a particular individual. So in terms of scheme actuaries, the starting point here is that the regulator in the UK, the Information Commissioner's Office, generally views professional advisors and specialist service providers as being controllers, not processors. And you recall in the previous slide the distinction between a controller and a processor. So if you are acting as a professional advisor, then generally speaking, the Information Commissioner will view you as a controller, even if you might think, well, actually, I'm acting on the instructions of my client here. And that's the same for a number of professions. So as a lawyer, the Information Commissioner views law firms as being controllers in relation to what we do with data, even though we're acting on client instructions. And where this becomes interesting is, as you'll probably know from the guidance that's been issued previously, scheme actuary is a personal appointment and it's distinct from the firm's role. And therefore, it's likely that a scheme actuary will be a controller in relation to what they're doing, independent of the firm that they work for. And I'm just recapping here the guidance which the IFOA has previously issued on this. Scheme actuary is likely to be a controller if they are a specialist service provider, if they are appointed in a personal capacity, and they're responsible for handling personal data. So if you tick all those three boxes, then you are likely to be a controller. But how that operates may depend on what you're doing, what your firm is doing in terms of the roles and responsibilities. And so you may not just be a controller on your own, but there's also a concept under data protection law of what we call a joint controllers, where you have more than one legal entity or person in a legal entity who jointly determine how data is being processed. So multiple organisations together are deciding how data is processed for a common purpose. And I know from my own dealings acting for clients that a number of firms take the view that they are joint controllers with the scheme actuary and also with the trustees. So what are the key issues? Well, I think step number one, are you actually processing personal data? Because if you're not processing personal data in your day-to-day work, then data protection law doesn't apply. Whether that is the case or not is a question of fact. Depending on what information you are handling, getting access to. But do just remember that definition of personal data is not just someone's name, someone's address, their date of birth. It's information that goes beyond that. So even if you don't have all those fields, potentially that is still personal data. And then, are you or your firm controllers? Well, I say that's a question of fact as to what you're doing under the particular engagement that you have with your client. But I think if you determine that you're not a controller, you're not joint controllers, then it's important, and you'll find out why when I talk about GDPR, to actually document how and why you've reached that conclusion. So on what basis are you determining that actually either you're not a controller or you're not processing personal data in the first place? Because if you don't record that and you don't have that clear, then if someone challenges that, it may be much harder to actually explain how you've reached that conclusion. And if you are a controller then, and this is the case just now under current law, it continues under GDPR, then it's really important, I think, to understand between you and the firm that you work for and your client as to actually how these obligations are discharged. So how are you allocating responsibilities between you all in relation to data protection law compliance? Just because you're a controller doesn't mean you have to do anything. You can contractually divide up liability and agree. There's certain things that your firm will take care of. They may act as a process on your behalf, or they may be a controller, or maybe you agree certain things that your client will do. So it's really important, I think, to document how you've reached your conclusions of what your position is, but then also actually how you're then discharging those obligations. So, the General Data Protection Regulation, what is it? Well, it comes into force on 25th of May 2018, so we are now 49 working days to go, or around about 71 non-working days if you're working, including weekends and that, so not long to go at all. And this is the biggest shake-up of data protection law that we've had within the EU for best part of 25 years. So as I said, the previous directive was 1995, and the way in which we as a society and organisations use data, the data we collect, has changed tremendously in that time. So what GDPR is about is updating those rules, making them fit for purpose for the digital, the information age, call it what you will, and ensuring that actually the law provides individuals with appropriate protection in relation to how that data is used and appropriate responsibilities on those who are handling that data. A couple of things to note. So I've said the enforced date is 25th of May. For many organisations, that is not an aspirational date, but their journey will not end on the 25th of May. Many will still be working towards compliance after that date. It's a regulation rather than directive, so that means that it has direct effect. There is a new data protection bill going through Parliament at the moment, which deals with some of the implementation matters. So, for example, how the Information Commissioner operates and some of the issues that are delegated to individual member states. But the main meat, the body of the legislation is set out in the regulation itself. And one of the things that will help with, and if you operate internationally, then this is a good thing, is there'll be far more consistency between different member states as to how data protection law is interpreted. Far more commonality, because you've got the same text and there should be consistent interpretation across the EU. Whereas at the moment, if you go to France or to Germany, you will find that some terms are interpreted quite differently, even though they come from the same directive. And to sit alongside that, the regulators have stronger powers. Talk a bit about what those powers are, but they're also bound by a formal consistency mechanism, which means that how the regulators operate should be consistent across the EU. And in the UK, that's quite interesting, because we've always had a very pragmatic, very business-friendly regulator in the shape of the Information Commissioner. I don't know if any of you have had any dealings with them professionally so far, but generally they take an approach of educating and helping people to comply rather than going to punish them first. They take a pragmatic view on a lot of stuff. Their guidance generally is quite sensibly drafted. But if you look at the approach of, say, the regulator in France or Spain or Germany, then they take a far more the individual approach, far tougher interpretation. And one of the interesting things to see with GDPR is how that shakes out with the consistency mechanism, because I think we will see the Information Commissioner have to become a little bit more aggressive perhaps in some of its views and things. They've said they're not going to do that, but I think they will have to do that. And perhaps a lessening in terms of the other regulators. So it'd be interesting to see how that impacts on the guidance we get. As I mentioned, there is UK law coming in as well. That will repeal the 98 Act and have a new data protection bill, finalised the next month or two. And all of this applies notwithstanding Brexit. So if you were hoping that Brexit will make this go away, that's not the case. GDPR comes into force before Brexit, and the EU withdrawal bill makes it fairly clear that a regulation such as GDPR automatically becomes part of UK domestic law when Brexit takes effect. And for various reasons in terms of international data transfers, the government has been very clear that they are not looking to do anything that will upset that. So GDPR is here to stay. And finally, just on the background, the analysis that I mentioned before in terms of the role of a scheme actuary and who a controller is and who a processor is doesn't change under GDPR. those core terms are the same, and I don't see any reason why the Information Commissioner will take a different view in terms of who they consider to be a controller or the tests for that. So, if you have settled on a position just now under current data protection law, then that position should hold good under GDPR. And why does all this matter? Well, it's compliance risk. It's the law. You will want to comply. If you don't comply, there may be regulatory action against you. It's a financial risk. The monetary penalties, the sanctions under GDPR are more substantial than at present. But even leaving that aside, things like clean-up costs of dealing with a data breach incident, management time compensation, whatever, add up. If you look at, say, TalkTalk, who were hacked a couple of years ago, they were fined £400,000 by the Information Commissioner, but the cost to the business has been put at £50 to £60 million. So you can see the actual fine from the Information Commissioner was very small there. What was the cost? It was the loss of customers, the clean-up costs, the damage to reputation, all that kind of stuff. Operational risk. So one of the powers that the Information Commissioner has under GDPR is power to issue an order to stop you from processing. And if you have to process personal data to do your job, then that sort of order, if they think that you are manifestly breaching the law, could cause a severe interruption in your business. So there's an operational risk there, not to mention dealing with audits and investigations and all that. And taking all that together, I mentioned TalkTalk and their loss of reputation. The reputational risk here, I think, is absolutely key, because you have adverse publicity, newspaper headlines, whatever it may be, loss of trust as well. So, and that's not just with the individuals, say a pension scheme member, but more importantly, your clients. If you suffer a data breach or you're not viewed as taking data protection seriously, then that may impact on who they choose to actually appoint to do the work. So, because that then impacts on their own reputation. So it is a fundamental reputational. For some organisations, it will be existential. So what's changing? Well, I mentioned that the key terms, the key definitions don't change under GDPR. So things like personal data, sensitive or special category personal data. So that's the greater protection given to medical records and information about sexuality, religious beliefs, trade union membership, all that kind of stuff. That remains the same. Who's a controller, who's a processor, processing, all that stays the same. And the data protection principles we have at the moment, so at the moment we have 8 principles, we have 7 under GDPR, they are largely carried forward. So those core principles remain largely unchanged, but they've been enhanced. And the rights of individuals that they have at the moment, again, the rights they have at the moment are carried forward, so subject access requests remain and rights like that. There's some new ones that I'll talk about. If you do any international transfers of data outside the EEA, then the rules, the framework in that remains the same. So the approach to that should be good. And data security as well. So the basic obligation to put in place appropriate technical and organisational measures remains under GDPR. You might think GDPR is about being more robust in terms of data security, but actually the test that's in the legislation is unchanged. What does change is that if you get it wrong, then the sanctions are more severe. And that's why a lot of organisations are dusting down those information security plans and thinking, are we actually comfortable that this does its job? And we will still have the Information Commissioner as our regulator in the UK. But all of this, I think, brings us back to, for me, if as an organisation you take data protection seriously and you do it well at the moment, it's a case of evolution, not revolution. So what's changing? Well, there are 2 big new principles that come in under GDPR. You may say the first one is already there, but it's certainly enhanced. The second one, I think, is very important. So the first of these is around transparency. And that's about being much clearer with individuals about what it is you're doing with their data and why you're doing that with their data. And I'll talk a bit about what that means in practice. Secondly, in relation to accountability, there are some changes. And this, I think, is, for me, if you look at everything that changes under GDPR, pretty much everything can be brought back to enhanced accountability for organisations to handle personal data. So an obligation to demonstrate compliance, that's new. A positive obligation to be able to do that is quite a challenge. Using things like data protection impact assessments and training and policies, all of these things feed together towards your accountability. And I'll talk a bit about what that means. Again, tying into that, there's an increased requirement for administration and record keeping, because if you don't have records of what you're doing, how can you be accountable for what you're doing? How can you know what you're doing? Data subject rights, as I mentioned, they're enhanced, and there's some new rights coming in. I'll talk a little bit about those. And organizational principles, so this thing called data protection by design and default, this idea that as an organization, you should be designing data protection into a new product, a new service, a new function, a new system that you develop from the outset. So you're thinking about, rather than being an afterthought, you're actually doing it from the outset. Data protection by default means that when you are, if there are options in terms of what data you collect or how you do that, you're collecting the minimum amount of data possible for that. It's for the individual to decide whether they want to share more information for an enhanced service or whatever it may be. Breach notification is new under GDPR, and I'll talk about what that requires in practice, and then I'll finish off talking a little bit about sanctions. So here's the principles that I mentioned under GDPR. I'll just rattle through them quickly. I say they are largely the same as what we have at the moment. Principle number one, you have to process data in a fair and lawful way and in a transparent way. So whatever you do should be fair, it should be lawful. So even if someone agrees to you processing data in a particular way, and they say, yeah, I'm fine with that, if fundamentally what you're doing is unfair, that would breach data protection law. You should only be collecting information for specified purposes and not using it for anything else. So if you collect it for one purpose, you can't then use it for another purpose without going back to the individual and telling them what you're doing. Whatever you collect has got to be adequate and limited to what's necessary for the purpose. So you shouldn't be collecting excessive amounts of data or sharing excessive amounts of data if there's no need for that in order for you to carry out the particular activity. And that data that you hold needs to be accurate and, where relevant, kept up to date. And in some cases, you don't need to keep your historic records up to date, but if you have information on, say, a live client, then that is something you want to be keeping up to date. So think about how you do that. And following on from that, once that purpose has reached its end and you perform that, then you should no longer be holding on to that data. So this is about records retention and records destruction, and actually having a clear policy and ensuring that once you no longer have a legitimate purpose for holding that data, it's deleted. That doesn't mean to say that as soon as you stop acting for a client, you have to delete all their files, because clearly you might need to keep them for a certain period of time beyond that, say for regulatory reasons, or even just to deal with complaints or litigation that might arise further down the line. But it's about being clear with how you're actually approaching that. Principle 6 is around data security, so ensuring that you are protecting it in an appropriate manner. And then the seventh principle is this accountability principle about actually being able to demonstrate your compliance with all of this. And I think that this, for me, is really, for the organisations I'm working with, this is the bit where they're having the biggest challenges, because on the most part, they know what they're doing is right. They're handling data in a reasonably compliant way, but they don't necessarily have a written down policy explaining how they know that they are doing things right. So that's around looking at your policies and procedures, documenting how you're actually processing data, what you're doing with it, how long you're keeping it for, how you're keeping it secure, your policies and sharing it, how you're doing that, how ensuring your staff know what they're doing. Because there's no point having a whole raft of policies if your frontline staff don't actually know what those policies are and actually comply with them. So it feeds to things like training. Data protection by design and default, we talked about current data protection impact assessments. I'll talk about on the next slide. And say there's an express requirement to keep, for most organisations, to keep records of their processing activities. So what data you're holding, for what purpose, how long you're holding it for, how you're keeping it secure, who you share it with, and this record is one of the core things that will help you comply. So even if you don't have an express requirement to actually do that under GDPR because you fall within one of the exemptions, I would still say actually having that record is core to actually be able to show that you know what you're doing with personal data. So data protection impact assessment. So this is something which the Information Commission has advocated in the UK for a number of years, but they're not mandatory. But under GDPR, they become mandatory where you are engaging in what's called, or what's referred to as high-risk processing. And essentially, it's a tool to sort of review what the risks are of a particular processing activity. Say you're going to procure a new IT system, or outsource something to a third party, or launch a new service, or do some new activity, maybe perhaps offer your clients a new service. As part of that, you should be looking at the privacy risks for that, for the individual, identifying what those risks are and the steps that you're taking to mitigate that, so you can then help actually document what you're doing and show that you're actually doing something in a manner that complies with GDPR. And for that reason, the regulators have said, yes, you only have to do it under GDPR if it's high risk, but actually if you don't carry out an impact assessment, how can you know whether or not it's high risk? So at least carry out some form of mini assessment before deciding whether you need to do a more detailed assessment. There's no requirement in GDPR to go back and carry out an impact assessment of everything you're doing at the moment, unless there's a change to the risk profile of that, but there is an expectation from the regulators that you will redo these things at least every 3 years. So it is something you want to look at in terms of your processes and systems you use, that you actually have done that. And one of the interesting things here is, so there's an express requirement to obtain the views of data subjects, so the individuals who are involved here. If you're going to launch a new service or do something different, how are you actually getting their views on whether what you're doing is fair, whether they consider that to be an okay thing to be done. So how can that consultation be done? And if you're one step removed from the individuals, that might be a more challenging thing for you to do. And going back to the transparency principle, the regulators would like organisations to actually start publishing these things on their website, at least in abbreviated form, again, to show, that from a transparency perspective, what you're actually doing. So moving on to transparency, if you process on the basis of consent, and I don't know how many of you do that, or if you're aware if you do that, if there's a form where you're getting consent or you're purporting to get consent, then you need to review what you're doing there, because the rules in consent are tightened up under GDPR. So you see there on the slide, consent needs to be freely given, specific, informed, and unambiguous, and require some form of affirmative action. So having something that says is consent buried in some terms and conditions, which no one ever reads, or a pre-tick box, or relying upon silence, all those sorts of things won't be valid consent. It needs to be a very clear statement saying, this is what we're going to do, tick box, I agree to that, or clicking a button to say, yes, I agree to that, if you're going to rely upon that consent and if it's going to be valid under GDPR. But consent can only be given where, as it says, where it's freely given. So if the individual has no choice, because in order for you to do what you're doing, you're going to do this anyway, then that's not freely given. So much better in those situations to actually look at the numerous other conditions for processing that exist under data protection law and identify which one probably suits better. And there are some specific ones in there in relation to pensions administration. There are conditions around doing stuff that's required by law. There's legitimate interest, where you're doing something that is within your legitimate interest and doesn't adversely impact the individual on a sort of balancing test. There's doing things that are necessary to perform a contract that the individual has. So there are many conditions processing that are far more appropriate for consent, I would suggest, for a lot of what you're doing. So review that. Bundled consent as well is something which is expressly prohibited under GDPR. So bundling together two different purposes and having a single tick box, again, that doesn't work. You need to break it down into the different purposes. Privacy notice, so again, this one might be an interesting one for you, given your role if you are a joint controller or even a controller in your own right. So under GDPR, there's an express requirement to provide individuals with a privacy data protection notice, setting out certain information. You'll see that on the slide there. So what's your legal basis for processing? If it's legitimate interest, what are those? If you're transferring internationally, details of what that is, explaining to the individual what your retention period is for the data, or how you decide that, telling individuals about the rights that they have under data protection law, and their right to complain at any time. And the challenge here is, well, aside from that, you have to do this in a concise, transparent, and intelligible form, which for some organisations will be challenging, because it'll be quite complex stuff that's going in there, and it'll be quite lengthy policies. It's the logistics, because if you collect the data directly from the individual, then you are required to provide that notice at the point of collection. But if you're getting that data from a third party, so say in your case from the pension scheme itself or whatever, then the requirement is to provide that notice when you start processing data or within 1 month after that. And there are some exemptions around where there's disproportionate effort, but I don't think they would apply for what you're doing. So this is, I think, about actually working with your clients and agreeing a common privacy notice that is then issued to scheme members so that they know what you are doing with their data, because otherwise you would have to go to contact them directly, which is clearly not feasible. So this is something to think about in your terms of engagement, how you actually manage this and who's responsible for doing that. And maybe you have a joint notice covering all of all of the administration is carried out, or maybe it's separated out in the different ways of dealing with it. On data subject rights, I mentioned that there's a couple of new ones. You may have heard a bit about the right to be forgotten or the right to erasure, which gets quite a lot of press. Quite a lot of not bad press, but quite a lot of misleading press. So this is not an absolute right. An individual cannot come along and tell you that they want everything you hold about them deleted in a way that is going to frustrate you doing what you're doing. It's a qualified right, and it only applies where you no longer have a legitimate reason for processing their data. So if you have a law basis, say you have to do to comply with law or to administer the scheme, whatever it may be, then you can continue doing that processing. They can't require you to delete data to stop you doing that. It's only absolute where you're processing the basis of consent and they are withdrawing their consent. And for me, really, this is just a check and balance on the data protection principle that says you shouldn't hold data longer than is necessary. Because if you no longer have a purpose to hold it, which is when this right kicks in, then you should be deleting it anyway. So if you comply with data protection law, then this shouldn't actually ever come up for most organisations. Data portability, again, this one's been getting a little bit of press, and this is the rights of individuals to actually port their data from one organisation to another one. But again, it's a qualified right, so it only applies where you're processing on the basis of consent or performance of a contract with that individual, and the data is processed through automated means. So this is really aimed at, if you are a bank and you've got transaction data, or you're an energy company, you've got smart meter data, and someone wants to shift that to another provider. I don't really see it really being terribly relevant for what you guys are doing. So I think, again, one you can hopefully not worry too much about. Data subject access requests are something which I think will be relevant and are here to stay. There are changes to the current rules, so at the moment we have 40 days to comply. That's reduced to 1 month under GDPR. There are certain rights to extend that in certain circumstances, but generally it's without undue delay and in any event within 1 month. And there's no right to charge the £10 fee that you can charge under current data protection law, though there is the right to make charges for excessive or repetitive requests. But generally speaking, you can dissuade people from doing this by saying you have to send us a cheque for £10. So that may lead to more people exercising these rights and therefore more administration to actually deal with them. And individuals also have the right to receive more information about the processing. So not just actually a copy of what information is held, but essentially everything that was on the previous slide there. So the stuff that you have to put in your privacy notice, they are entitled to get when they put in a subject access request. Again, if you have a well-drafted privacy notice, then that shouldn't be difficult to comply with. I mentioned earlier on about processors and the changes. So at the moment under data protection law, processors don't have any direct obligations under data protection law. They just have to comply with the contract with the controller, and the controller is accountable for everything that the processor does. That changes under GDPR because processors obtain direct obligations in relation to record keeping of what they're doing for their controllers, cooperation, consultation, use of subcontractors, but perhaps most importantly, data security. So at the moment, most processors have in the contract, they say what they will do. They say, here's our standard IT security policy, we'll comply with this. Whether or not that's sufficient for data protection purposes sits with the controller. But under GDPR, that burden shifts to the processor. So if you are a processor, you might want to be looking at your contract and your data security measures and ensuring actually you are comfortable that you can stand behind them, because that accountability sits with you. Data breach notifications as well, there's an obligation to tell the controller about any data breaches you suffer. And there are specific requirements in terms of what now needs to go in a contract between a controller and a processor. So there's a list of half a dozen or so clauses you need to include, specific obligations, controls around subcontractors that now need to go in those contracts. So if your firm is acting as a processor, then you want to ensure you're reviewing those arrangements with your clients. And there's no grandfathering of existing contracts. So the fact that a contract was signed last week or last year, 2 years ago, doesn't mean that it's exempt from GDPR. GDPR applies from the 25th of May. So you'll want to think about how you update those contracts or deal with those risks. Data breach notifications, again, a little bit like impact assessments. This is something that in the UK, the Information Commission has been very keen on organisations to do over the last few years. it's now a statutory obligation. So there's a duty to notify the Information Commissioner if you suffer a personal data breach within 72 hours, unless there is no risk to the individuals arising out of that breach. And that's 72 hours, not 72 working hours. So if you suffer a breach, say on a Friday afternoon, that means the breach has to be notified on the Monday afternoon. So not much time to actually think about what's happened, investigate, decide whether or not there's any risk to the individuals, be able to come up with sufficient information, you can actually make a notification. So what's important here is ensuring as an organisation you have an appropriate procedure in place internally. The staff know about that, they know who to contact or tell if they think there's been a data breach, so that can be investigated and the necessary steps taken. And there's also a requirement potentially to notify individuals as well. So if there's a high risk to that individual, then you need to tell the individuals. And again, going back to being a joint controller, thinking about how you're doing that, because I suspect most of your clients won't want you writing directly to the individuals and saying, we suffered a data breach, here's what's happened. You need to think about how that's done in a joined up way and how that is managed. So finally, just moving on to talk about regulation enforcement. So the Information Commissioner is getting a raft of new powers, not just in terms of sanctions, but in terms of investigations as well. So the powers to do things like to enter premises, to carry out audits, to carry out investigations, to compel organisations to provide information, that is increased under GDPR, and I'd be interested to see how those powers are exercised when they're dealing with complaints. But as I mentioned, there are increased powers to fine, I'll talk about that in the next slide, but also the ability to issue orders to ban processing. And I think that sort of stuff, potentially is more damaging than being issued with a fine, because a low fine, yeah, you can pay the money for that, that's fine, but actually an order saying stop processing until we have satisfied ourselves you are actually doing it in a compliant way is far more intrusive and interruptive to your business. So just be aware of that. On fines themselves, so yes, you'll have heard the headline figures about 4% of worldwide turnover and 20 million euros being the maximum power to fine, but it's a maximum power, and any fine that's issued has to be proportionate and effective and dissuasive. And what we've heard from the Information Commission on fines is very much that they are not expecting to be issuing hugely bigger fines than they are at the moment. They will take the same approach. They've never used the £500,000 fine that they have at the moment. The highest has been £400,000. So they're not immediately going to jump and start fining organisations disproportionate amounts of money. I expect they'll be largely around about the same. But what's potentially more interesting is that you can have fines for administrative breaches. So at the moment, it has to be substantial distress or harm to an individual in order for there to be a trigger for a fine to be issued. But GDPR says that actually not keeping good records, not issuing a privacy notice, all those sorts of things are potentially areas where fines could be issued. So if the Commissioner views you as blatantly disregarding data protection law and just turning a blind eye to things on the record-keeping side, then even if it's a near miss and there's been no harm to the individual, you may well find that they take more substantive action. Okay, so just before I hand over to Chris, talk about preparing for GDPR. I mean, hopefully all of you or your firms are started on this journey. If you've not, then the Information Commissioner has a very handy checklist on their website, so 12 steps to take for GDPR compliance. And they produced a huge amount of guidance in the last couple of months to help organisations to work through GDPR. Reasonably well drafted stuff that's very helpful in terms of breaking GDPR down. For my part, what do I think you should be doing? Well, resource, work out who your team is, how you tackle it, making sure you've got input with it across your organisation, understanding how you're actually dealing with that, board level sponsorship, funding, whatever's required at the time to actually do your preparations. Data mapping, actually mapping out what it is you're doing with personal data. So writing it down, working out where the data comes from, what you're doing with it, who you're sharing it with, how you're protecting it. Because if you don't have that, then I don't see how you can prepare and be compliant. Data minimisation, I mean, now is a good time to reduce, if you've got historic files you've had on to for a long time, now is the time to start sifting through that and breaking it down and getting rid of stuff you don't need anymore, because the less stuff you hold, the less risk there is of a breach. Review your process and justification. So I know a lot of organisations rely upon consent at the moment. It's probably not compliant under the current law, never mind GDPR, so now is a good time to be looking at that and working out what your correct legal basis is and looking at the contracts that you have with third parties. So how does that translate into key actions? Well, firstly, if you are a scheme actuary, then and confirm what your status is. So understand, are you an independent controller? Are you processing personal data? Are you a controller? Are you a joint controller? If so, with whom? Is it with the scheme, or is it also with your firm as well? And understand status of your firm as well within this. Are they a processor? Are they a controller? Because you need to have that overall picture to understand. And that may vary from scheme to scheme, depending on what your engagement is. Undertake the data mapping exercise, update your privacy notice on the back of that, so explaining to individuals what you're doing with data. And understand your personal obligations under GDPR. So if you're a scheme actuary and you're a controller, you have personal accountability for compliance. So how does that impact on you as an individual and your personal liability? How are you dealing with that? And work with your firm to work out how you actually go about achieving compliance. So you'll be reliant upon them for a lot of the policies and procedures, the IT systems you're using, all that kind of stuff, the support that you get, doing risk assessments. So understand what support you're getting there and how you're achieving compliance. And then finally, looking at your contracts. So it's not, and this is not just between you and your firm and the client, your terms of business, but also between you and your firm yourself. If I have personal liability in the process of my job, but I'm employed by someone to do that job, what protection is my firm, my employer giving to me in relation to how I do that? So I don't know if that's something any of you have looked at, but it may be, now is a good time to actually think about how that, the sort of paternal sort of employer responsibility sits with your personal liability as well, worth looking at. And with that, I will hand over to Chris.
Martin, thank you very much for that. That's, I'm sure you'll agree, colleagues, a very, very comprehensive review of a complex and important piece of legislation. And I suspect there are a number of themes that we're going to want to return to in your questions to Martin and Chris. So let's keep those questions, as it were, on your hat for the moment. I'm going to ask Chris now to speak to us. And remember, Chris is going to be looking at this aspect, as it were, from the perspective of the scheme actually. So, Chris?
Thanks. So I'm just going to talk for 5 or 6 minutes about how my firm, LCP, is dealing with the key actions that are up on the screen. And then we'll throw it open to questions, so get thinking about those. First of all, it strikes me that a lot of what's happening under GDPR we should have been doing already, and I'm sure most firms were doing already, but the fact that everybody is looking at it has given us all an opportunity to look back at our existing policies, procedures, and make sure that they remain fit for purpose in the new world. So in a sense, it seems to me that the job is bigger than perhaps it must be, because we are taking the opportunity to do a bit of a spring clean at the same time. But just turning to the points on the screen, as I'm sure a lot of you know, it's been perhaps a little bit of a moot point about whether scheme actuaries are data controllers, whether they are joint data controllers with the trustees of the pension scheme, or whether they are data processors. And I think different firms, and indeed different law firms, have taken slightly different views. Our view at LCP, based on our legal advice, is that scheme actuaries are joint data controllers with the trustees. And as part of that, with all of our clients a few years ago, we set out an agreement about, okay, we're joint data controllers, there's 8 data protection principles under the current legislation. Who is going to do what under each of those 8 principles? And that agreement is in place with all of our clients. But we are updating those, so we've produced side letters, again, for all of our clients, actually in all business areas, not just in scheme actuary areas, to update our existing contracts. So that, as you can imagine, that's been quite a lot of work, and it's been quite a lot of practical work, paperwork of getting these things out to all of our clients, and a lot of them are now coming back countersigned and agreed. Alongside that, we've produced a data mapping for all of our scheme actuary work. This, although in fact the data mapping that we've come up with is only 2 or 3 pages long, it was quite a long gestation period to produce something, and we had various drafts. To start with, they were all very detailed, and then we realised that, okay, that might work for Scheme X, but it doesn't work for Scheme Y, so we'll have to tailor it. And so in the end, we settled on something that is a little bit more general and can be applied to all of our Scheme Actuary clients, and we've got similar data mappings for other business areas as well. We do insurance consulting and obviously corporate pensions consulting as well, where we're not Scheme Actuary. And we've got similar documents. They seem to have gone down very well, actually, with clients, because it may not be absolutely specific to exactly what we always do for that particular client, but most people can read through it and say, well, yes, that's the sort of thing that we expect our Scheme Actuary to do. Privacy notices, again, they were done under the existing legislation. Our agreements with our trustee clients is that the responsibility for the privacy notice rests with the trustees, but trustees will need to be updating those as well. And obviously we'll cooperate with that and help with that where we can. The personal obligations that Martin was talking about, that's something that is very much on my mind as a Scheme Actuary. So if I am personally a joint data controller with my trustee clients, what liability do I have? So to settle that point, again, under the existing legislation, LCP, the firm, wrote to all of the individual Scheme Actuaries, effectively indemnifying us for any negligence, because personally we don't have PI insurance. We rely on the firm's PI insurance. And obviously we're relying on the firm's IT systems and security systems and everything, and policies and procedures around the data. I've mentioned actually about working with your firm to ensure compliance. These policies and procedures, we've taken the opportunity to spring clean them, see whether they're still fit for purpose, and indeed, let's be honest, write some of them down, because again, under the previous existing legislation, I'm pretty confident that we were complying with it, or we have been complying with it, but not everything was absolutely clearly written down. And we've taken the opportunity to address that. Some things are actually more important that they're written down now because, for example, the obligation to notify breaches within 72 hours, if you don't have a policy or you haven't thought about how you're going to react in advance, if there were to be a data breach, rushing around and deciding what to do with it and how to liaise with your clients, etc., in a 72-hour period where that might be an Easter weekend is not easy. So it's much better to think about it in advance and agree it internally so that should the worst happen, we know what to do. We've also been looking at things like our retention policy for data and for client files generally. What happens to our computer backup systems? How long are those, I'll say tapes, I think there might be disks these days, but how long is that information stored for? How long should it be stored for? Clearly with a pension scheme, it's a long-term entity, so there might be an argument for keeping things for a long time. On the other hand, should we really be keeping data that we collected 40 years ago? Is that reasonable? And we've come to a landing on that after some discussion, and that's another policy that we've been working very hard on. And then finally, I'll mention something that surprised me. Perhaps it's not strictly a Scheme Actuary responsibility, but something that surprised me was in doing this spring clean, we looked at all our contracts with suppliers because, for example, an obvious supplier might be there's a firm that looks after our IT service, and they're kept off-site. So clearly, the data that we are collecting and processing to do actuarial valuations as scheme actuary is held on a server that is held by a third party. Clearly, we ought to look at that contract and make sure it has appropriate GDPR provisions in it. That one is easy to understand that it's something that we ought to do. But in fact, our legal team has looked at all of our suppliers, and surprisingly, there's about 300 of them. And there'll be suppliers for everything to do with the firm. So the IT supplier is an obvious one, but we'll also have people who come in and repair the air conditioning, change the light bulbs, water the flowers. All of those sort of people may or may not have access to confidential information, particularly if they're coming into the offices unaccompanied at a weekend to repair systems. So we need to have appropriate contracts in place with them to make sure that there's no possibility of data leakage. So that's something that our legal team have been working very hard on. Of all of those 300 suppliers, every single contract has been gone through and agreements reached about how they are dealing with the data, and appropriate GDPR provisions have been put in or are being put in, and that will all be in place by the 25th of May. So I'll probably leave it there. I've said that's a few things about how LCP is dealing with this. Very happy to hear how other firms are dealing with these issues as well.
Chris, thank you very much for that. So we've reached the point where we can now deal with questions, and I hope there are going to be lots and lots of questions and an exchange of views, both from the panel to yourselves, but across, as it were, the various tables we've got. Can I just remind you that if you're going to raise a question, we'll bring a microphone to you for purposes of recording. If you don't want to be on the subsequent recording, it's going to go on the IFOA site. Speak to us afterwards and we'll make sure that you're removed. When the microphone comes, if you'd like to introduce yourself and your organisation, that would be great. If you would prefer not to, and who knows, there may be lots of questions whether you'd like to keep some degree of privacy, we'll understand that as well. So either way is absolutely fine. What we're keen to do is to get as many questions as we possibly can. So who'd like to go first? We need a volunteer, otherwise I'm going to have to ask somebody. Yeah, gentleman over there, the microphone's right on its way to you.
Yes, it's Martin Raw, and it's about international data transfers and privacy notice. And I'm just wondering if you have a server overseas and you're actually sending data internally, how does? But obviously that data could stay on the server overseas. Do you have to disclose that within your privacy notice?
So is this part of your IT infrastructure is hosted
yes.
outside the EA?
Yeah.
Is that?
Yeah.
Yeah. Do you know whether that server is owned by? Is it owned by a sort of a Rackspace or a Google or something like that, or is it another group company? Or
good question. I don't know. So the answer on the both basis. We might have it, or it's owned as the third party.
Certainly, if you're using hosting infrastructures outside EA, then yes, that is something you would want to include in that, and whether that is a transfer to another entity, another legal entity, or whether it is to another member of your group, or whether it is to an IT service provider, it will depend on what level of information you need to put in your notice. But yes, that would be an international transfer that you would need to explain in your privacy notice.
Okay, thank you.
So understanding precisely what the supplier to Martin's firm is doing in terms of defining that international transfer is going to be quite important, I guess.
Yeah.
So
and
getting them to reply with precision in time, that's something that needs to be addressed quickly.
Yes, and it's something that you would, firstly you need to know who they are, where they're storing it, understanding, for example, if it is a third-party provider, can you say, actually, I want my data to be held in the UK or in the EU or whatever, or whether they just hold it wherever it is. Most service providers these days will allow you to have some form of geographic restriction. But then it's something you would then want to record in your data as you register processing activities, your the data mapping exercise I mentioned earlier in the presentation. So you've got a record of that somewhere.
Okay, thank you.
Okay, next. Who wants to come on? We've got a question at the front here, and then we'll go to the gentleman right at the back.
Hello. I'd like to ask about whistleblowing, where so you have a trustee client, and the trustee on the 25th of May hasn't issued its updated privacy notice. Would you regard that as a whistleblowing offence?
Right, who'd like to go first on that one, Chris or Martin?
I think it's a legal question.
I'll give you my view. I mean, it comes down, I think, partly to whether you are a joint controller or whether you are, what your position is. If you are joint controllers, then I think it is something you need to sort out with your client, because you are jointly liable for the non-compliance, which is issuing that privacy notice. Now, clearly, I suppose, what practically can you do if they are refusing to do that? Could you threaten to withdraw service, that kind of stuff? What options are available to you? But yeah, I think it is a concerning thing, and I know that some trustees are sort of struggling to get up to speed with this. So in terms of what they're doing, so any help you can give to them, to help them on their way, because remember, it's not just about their compliance. If you're joint controllers, it's about your own compliance as well. Whatever you can do to help them would be important.
By your own, are you talking about, as it were, the firm or an individual IFOA member?
Well, both. Yes. If you are, either you or your firm are joint controllers, then you will want to do that.
I don't understand. Ben, I think you want to come in?
Thank you. Just on the same point, Martin, I mean, assuming this is not a deliberate attempt to avoid or circumvent the requirements, do you and this is just a question of people getting up to speed as we approach 25th of May and indeed thereafter, do you expect, Martin, that the regulator will, to coin a phrase, cut a degree of slack in terms of where people are clearly making reasonable endeavours but haven't quite got there at that point?
Yeah, I mean, I think yes, they will make they will potentially make some allowances. The other thing to bear in mind is that they are understaffed, they are under-resourced. They are only going to investigate something when someone complains to them. So for so long as this doesn't go on their radar, they're not going to be doing anything about it. So that, I suppose, is maybe the sort of practical risk assessment here.
Although I suppose you could say that adds even more poignancy to the question about the obligation in relation to blowing the whistle.
Well, indeed, yes, but I think to go back to Ben's point, Ben's question, it's about working out what you can do, and would they cut you some slack in that situation? Well, I think it depends what you've done. The privacy notice is arguably one of the easier things to do, because it's kind of one of the key transparency principles. If you can't tell me what you're doing, then that's difficult. I suppose the other thing, just to finish off on that, is that the conversations that we've had with the Information Commissioner on issuing new privacy notices for existing processing activities have suggested to us that you may not necessarily have to push out a new notice to everyone straight away. If you're not changing processing activities, if you're simply updating your notice to reflect GDPR, but you haven't quite got around to mailing it out to everyone, then I think on that they will take a sensible view. So the example given to us is that the next time a customer or client data subject engages with the controller, whether that's say the annual renewal of a policy or whatever it may be, a service, then that point might be the appropriate point to issue your updated notice. But you would still need to have the new notice in place for new people who come in, who come into the scheme. So the administrative part of actually sending a posted message out the door or an email to everyone, there may be some leeway on that.
I wonder as well, just thinking about the question as a point here, that there are also implications for the actuaries' code in terms of whistleblowing, speaking up and so on and so forth. Anyone else want to comment on that? Or whether our question wants to come back at all?
Well, I'm just worried that I think a lot of trustees are actually on the deadline, not sorted things through.
Yes, I suspect in some instances that will be the case. I mean, it's a very, very significant series of tasks that have to be accomplished to achieve GDPR compliance. So it's understandable perhaps that some trustees will be less prepared than others, so I take your point. Let's move, if we may, to the question at the back there. Thank you for that.
Thanks. John Berman, Willis Towers Watson, but speaking in a personal capacity. A question really on what I believe to be chimera of the joint controller that I think has been emphasised by the last couple of questions. The suggestion is that you, the actuarial firm, are jointly responsible for the actions of your trustees. When your trustees make a DP error, you have liability, and vice versa. In my respectful view, that is a nonsense. I accept that the concept of joint controller is difficult. It's difficult because in the UK we have concepts of controllers in common, which in the EU would be reflected as a sort of co-controller. That is, separate and independent controller, which we all know and we all understand. Joint controller is a different ballgame completely. It's where it's suggested that we process data for the same purposes and with the same means as our trustees. I just don't buy it. I was wondering if there are any comments on that.
Before we go to the comments, and if there isn't that concept of joint controller, what difference is that going to make in terms of some of the obligations we've just been speaking about?
I think, very simple. Rather like accountants and solicitors, who are separate and independent controllers, they have primary liability and responsibility for data to the data subject. So they screw up, they are liable. As an independent and separate controller, processing personal data for their own purposes, they have absolute responsibility for that. So the fact that an actuary has a data breach, say, better example, the trustee has a data breach owing to some default or defalcation they've got, maybe, for instance, because they do not have one of the data processing agreements with a sub-processor or a sub-sub-processor, wherever. Why should the actuary be liable? It just doesn't make any sense.
Okay, see your point. Martin, if I come to you first, and Chris, you might have a thought on this.
So the first thing, I suppose, just to say on joint controllers is that you are allowed, and indeed GDPR requires, and currently it's not requires, that joint controllers agree between them how they are discharging their obligations. So whether that is documented in a formal agreement or some form of MOU, whatever it may be, you can divide up responsibilities. So you can say, for example, and I think Chris may have said this is what his firm does, is that the requirement to issue the privacy notice we have agreed is something that sits with between us, is something that sits with the trustees. And similarly for other things, you might say, well, for the IT systems used by the scheme actuary or by the firm, then responsibility for that sits with the firm, and the pension trustees are not responsible for that. So you can divide up your responsibilities and do that in your terms of business. And that is then something that the Information Commissioner would take into account if they were taking enforcement action, as to what, how you would approach that. I suppose just on the previous question, I suppose my point I was making is that the privacy notice needs to cover what everyone is doing. So if you are saying to your trustees, well, you have to issue the notice that covers our processing activities, then, and they've not done that, then that is, I think, where the risk kind of comes back to the firm, and you have to think about how you manage that.
Can I just very quickly respond to that? I agree with every single word you've said. Absolutely, and you're 100% right. However, the famous but. However, let's take the example of the data subject. The data subject is the one that's going to be making the claim, either through the ICO by way of complaint, or, and I suggest this is a little bit more worrying following the recent Morrison's case, where you were to get a direct claim by a data subject or group, a class action, against you for some form of data breach. In such circumstances, you may have agreed a lovely deal with your trustees, fine, assuming the trustees are still in existence. But the reality is you're both going to be jointly and separately liable to the data subjects, or class of data subjects, if there is a class action. That's the scary bit. And that's the bit that you cannot absolve yourself of liability, because Article 82 doesn't let you. So that is my fear and my misunderstanding as to why the actuarial profession, as I say, in contradistinction to solicitors, to accountants, somehow feel that they are joint controllers.
Okay, Martin, do you want to come back on that?
Just to say that the arrangements you have between joint controllers could cover liability as well. So you could have indemnities in there to deal with that or whatever.
Agreed, but forgive me, and this is my last word on it, you're absolutely right. They'll have indemnities, of course, but forgive me, the trustees go, well, let's assume the worst happens, the trustees go bust. There's a huge class action claim made by the data subjects. I accept, of course, you'll have indemnities for what their work, in those terms, is going to be worth. My question to you is, why accept the liability in the first place, when, in my respectful view, that liability does not exist? It doesn't exist, as a matter of fact, for the processing you're doing. You're doing processing for different purposes.
Okay, so let's make sure we all understand this, because it seems to me that your central charge is probably, I think you may be making a couple of points. Let's assume for the moment that there is a valid concept of joint controllership, if I can call it that. As I understand John's challenge, that what he's saying is that notwithstanding that I might make an agreement between you and me, trustee, scheme actuary, to allocate responsibilities, that isn't going to vitiate the fact that I may be jointly and severally liable with you because I concede the concept of joint controllership. If there's a problem because it's a class action, the only one with insurance or deep pockets may be the scheme actuary. So do you want to come on that point first?
I think, well, that's absolutely right. Yes, I don't disagree with that. I think it comes back to, though, the question as to, as you say, are you joint controllers or are you not? And that I think is a question of fact.
Quite. And so, again, if I understand the points you were making in your presentation, it seems to me you're saying that the status of joint controllership, subject to the specific facts, can exist. It is going to be a status that you cannot contract your way out of.
If you're viewed as jointly controlling with another entity.
So taking, I think, if I quote John correctly, some of his last point, well, why accept that liability? It seems to me that, subject to possible differences to the fact that controllership can be joint, if it is a joint entity, a concept that can be a joint controllership, you cannot contract your way out of that. It's going to be driven by the facts of the matter. You either are or you are not a controller / joint controller.
Yes, it is a matter of fact as to what your status is. You can contract around that in terms of what comes from it. Yeah.
Chris, is this a problem that you've been struggling with and tussling with?
I wouldn't say we've been tussling with it, but I do accept that maybe there is some residual liability. I mean, at LCP, we've done the best or the most robust job that we thought we could. So we've taken the view, acting on legal advice, that we're joint data controller, scheme actuary, and trustees. We've divided up those 8 data protection principles and the various duties under them and said, well, who should do what. But, yeah, I don't know. If it ends up being joint and several liability, maybe something might come back to me personally, but then I have the indemnity from my firm, and my firm has insurance. That's probably the best that we can do, I think.
So you're seeing this as almost as it were an inherent risk of being a player in this game?
If we accept it's a non-zero risk, then I don't really see how we can get out of it.
Okay. I'd like to move on, if I may, to the next question, next subject. Maybe we can come back to over refreshments. Yes, if you just wait for the microphone, sir.
Thanks for presentation. I have actually 2 linked questions, and actually one of that is linked to this question as well. So given the scenario that, for example, if one individual professional caused a data breach, and he obviously works in a firm, and then in terms of the responsibility to notify within 72 hours, is that the individual's responsibility, or is that the firm's responsibility to report the breach within 72 hours? And then the second question is, if that scenario happens, is it more likely that the damage or the indemnity is covered by the individual professional's professional indemnity insurance, or is this more likely to be covered by the company's cyber policy, for example?
Okay, right, let's...
Should I take the first question?
Yeah.
So in terms of the breach notification obligation, that sits with the controller, whoever the controller is in that case. So if you are a scheme actuary and you are a controller in your own right, then that obligation would technically sit with the individual. But as I said in my my closing slide, so I think this is the sort of thing where you would probably be looking for a lot of support from your firm in terms of how you manage that, how you investigate it. But the obligation sits with the controller, whoever that is. If you are joint controllers, then you would want to be agreeing between you who is responsible for reporting a data breach.
So again, understanding that status, controller, not controller, joint controller, critically important. I guess also vitally important, given that potential for personal liability, is to have clarified in writing the relationship, the arrangement with your firm.
That's right, yeah.
Okay, I suspect in terms of the second part of the question, so is this sort of liability going to be covered under an IFOA member's professional indemnity insurance or the cyber policies of the firm? My sense would be, I don't know what people would think, that it's probably the case that your professional indemnity is going to cover that.
Well, I said professional indemnity, but perhaps it is some other insurance policy, but I'm confident that LCP has all the insurance it needs, and I have an indemnity from LCP that I can rely on that.
Because it's my sense that the terms of cyber policies, that the wordings are, I think, in a state of flux, and there's a lot of change underway there. So it's really, I think, very difficult for anyone on the panel to express a view as to whether look to my cyber policy or not. I guess that may be driven by the nature of the causation of the breach. But there's probably an overriding point here about being very clear about what insurance arrangements, what policy covers are in place.
Yeah, so if your PI insurance covers your negligence, but it's not arisen from your negligence, but you've just been the victim of a hack, that may or may not be a breach of data protection law. The negligence and a breach of data protection law may not actually sit quite side by side, so it could potentially be covered by both.
Okay.
Because one thing that is also interesting is PI policy doesn't cover, say, fines and penalties, but under the GDPR, the fines and penalties is not uninsurable by law. So potentially cyber could pick up the fines and penalties if there is any, caused by the individual's, negligence.
Yes, I think that must be, I would have thought, colleagues, a possibility, because my understanding of sort of cyber policies is that they would potentially pick up that fine, because that would be a consequence, as it were, of the hack into your system by the attacker. Okay, thank you for that. Let's move on. Who's got the next question?
Okay, well, I hope the answer to this question is be pragmatic. It's a question about data retention. For data you may or may not realise you're holding, perhaps from 15 years ago, back in the early noughties. So are we expected to trawl through all our laptops, all our systems, every single email, delve into that email, and it might be a chain, and you may not even realise that you were copied in on the chain, but right at the end of that chain, there's a little Excel spreadsheet with some personal information on there. Are we expected to actually, to what extent are we expected to actually do a backward-looking trawl just to establish and get rid of data?
It's a difficult question. It's a difficult thing to deal with. So this is all about trying to reduce your risk, and if you can take steps to reduce the data that you hold, as I said, that then reduces the risk of you suffering a data breach in relation to that. So I guess it's about what you consider as proportionate in terms of doing that and what you can do to mitigate it. There's no sort of rule for Spain that says you must review every email or check what you're holding. I suppose my question would be why have individuals got large inboxes on their laptop of stuff that is not being managed. It is, as I understand it, possible to require a policy whereby any emails in the inbox are automatically deleted after whatever it is, 6 months, a year, whatever, and you could require everything that is relevant to the firm is filed in some form of organised filing system. So I think that where it gets to is if, say there's information on someone's laptop and it's not secured in some way, or there's a data breach occurs in relation to that, then how would you answer a charge that actually you had data you no longer had a reason to hold? And that, I think, comes down to training, and it comes down to, say, your IT policies as well.
And, I mean, this is something that LCP have been looking at very carefully. What is our data retention policy? How long are we keeping things for? In the old days, everything was on paper, and I expect, like many firms, files were put into archive boxes that were archived goodness knows where, in a disused train tunnel somewhere. I don't know where they go, but wherever they are, we've thought, well, actually, how long are we keeping these things for? And should there be a difference between if it's an existing client, a pension scheme client, then maybe you do have a legitimate reason to keep pension scheme records going back many years. But particularly if it's an ex-client, you need to keep information for a period of time in case there's any claims from the advice that you've given. But there is a temporal limitation on bringing claims. So whatever that number is, it may be 6 years. After 6 years, say, or there may be a long stop of 15 years I've heard talk about. But whatever the number is, there must be a period where you say, actually, we've got no legitimate reason to keep it, and there's no chance of having a claim against us, so we'll destroy it. So we are looking at that retention policy and making sure that it is in line with the GDPR. And indeed, perhaps we should have looked at it before, but we are taking this opportunity to look at everything fresh and do a spring clean.
I guess, though, taking the thrust of that question, there are potential issues, and you may disagree with me, potential issues for a firm, for individuals, both in terms of, first of all, GDPR obligations, but I suggest also litigation risk on the back of a GDPR breach.
Yes. Yeah.
And so does that suggest to me then that there's an obligation certainly driven by GDPR, that having a clear policy and seeking to apply that policy in a rational and sensible way, and I'll come back to rational and sensible in a moment, would be something that I guess you ought to be putting in place now. I suppose the question about how rational, how sensible it is, and I think this is really a key part of your question, how far back do you go, how wide do you check to see that you're consistently applying or appropriately rolling out that new policy to your historic data? Really difficult to give any definitive guidance and answers other than that you need, a rational position that's well argued, that's documented, that's been thought through, and in your context is reasonable.
Yes, and I think if you don't have some form of sort of organised document management system where you can store emails that are relevant to the client file or whatever, then it's a much harder job, because you don't. If you've got that, then you can clearly say, well, that client, everything that's relevant to that client is stored on there. We don't need to write anything else, and therefore you can cull stuff in people's inboxes beyond that. If it's important to the firm's business, they should be saving it somewhere, whatever your policy requires. But if you don't have that, and things are kind of much more ad hoc, and they're stored in people's local drives or whatever it may be, then that just becomes a very, very difficult job to manage. But that then comes back to generally my point around data mapping and knowing what you hold. And actually knowing that you've got what you should have, you're not keeping it for longer than necessary, you know where it is and it's being kept secure.
So it feels to me that do nothing is not an option.
I'd agree with that.
You need to have a think about it, and perhaps you also need to make a note yourself about why I didn't go through absolutely everything, because I've had to draw a line somewhere, but just documenting to what extent you did do that, and how you formed a judgment on what was practical and pragmatic and sensible under the circumstances.
Yeah, and I think how you maybe set the parameters about how far back you were going to go, how quickly you were going to do that, as it were, that backward review. Again, I'd suggest, and colleagues on the panel may disagree with me, but that at the very least putting your house in order in terms of what's going to happen, of where you're going now. I think having seen that must be, I would have thought, a really critical first step. How quickly then you go backwards, if I can use that expression, something that's going to be very case sensitive, case specific, I would have thought. Right, another question or another issue that anybody wants to raise?
There is in existence, I think, the guidance from the IFOA under the previous data protection arrangements, which is to be withdrawn, I understand. Is there any particular reason why there's not going to be a new version, new GDPR version?
Well, Ben, would you like to respond to this? Let's wait for the microphone to get back to you.
Thank you. Okay, so we don't currently propose to reissue the guidance in its current form. We are, however, going to provide CPD resource for members, and in particular the material from this session, from the webinars that we've done, the webinar we did the other day. We're going to have all of that online. We anticipate doing some form of sort of FAQ type material, drawing on the questions that have been asked tonight, the questions that are asked on the webinar, other questions that, if you have other questions, please feed them in. We will pick those up. Whether we pick them all up individually or cluster them in terms of themes, we will endeavour to do that. I think we think that's probably the more sensible, pragmatic thing for us to do in terms of supporting members. There's a question as to how appropriate, I guess, it is for us to be seen to issue formal guidance when we're not the regulator, and the regulator is producing lots of guidance, and there's more of that coming now as data protection gets more complex under GDPR. So we'll be signposting what it is producing as well. But we're very happy to hear questions, hear concerns, hear issues, attempt to address them this evening, and indeed through the resource we're putting together on the website. Hope that's of some help.
If I may, because actually if you want to come back on that, but just to add to that, again, it's to stress a point that Ben made, that we're very, very keen to hear, as it were, from members if there are concerns and so on and so forth. And let's say we identify, I don't know, 3-4 months downstream, in the light of ICO guidance, a particular or a specific issue that is affecting scheme actuaries. If that requires us to take some action, whether we issue some case studies or we go and talk it through with our professional advisors and the ICO on behalf of members, then we'd be very, very open to doing that. So if there are concerns that you've got, if you've got suggestions around that, if there are practical issues that emerge, as I say, a few months down the line that people haven't so far envisaged, that are causing specific problems for scheme actuaries, then we'd want to hear about that and we want to act upon that. Can I also just remind you that the IFOA does have specific mechanisms in place to provide help and assistance to members that obviously are going to apply in this context, which clearly you might want to make use of. Question just here? Sorry, unless you wanted to come back. Did you? You okay? And then we'll come to you, sir, in a second.
Maybe this is one of those suggestions then. One of the useful things, I think, in the previous guidance was, given the particular concept of joint controller for professional advisors, so something very specific to somebody like a scheme actuary, which isn't perhaps easy to find in the general guidance from the ICO, like the allocation of responsibilities. When Chris has referred to, it's often been used, I think, in people's contracts with their clients. So something like that might be easier to provide from the IFOA rather than trying to hunt it down in more general stuff from the ICO.
That's a good point, and I'd like to think that sort of thing is going to be captured by the point that Ben was making, that when we try and distill the material we put together with the benefits of our various panels across last week's webinars and this evening, that we will try and capture that. But I guess I hope you think it's a reasonable point, that we didn't think it was for us to be issuing guidance on a matter that clearly falls into the bailiwick of the UK regulator in this matter, ICO. But as I say, I think your suggestion is a good one, and I would like to think we're going to pick it up by utilising the materials from tonight and the webinars of last week and so on and so forth. So.
If I understood Chris right, you had a debate in your own firm as to whether you're data controllers or data processors. and you opted to conclude your data controllers. Is there any argument for you not to be a data controller? Is there any legal argument to justify being a data processor? I mean, in my case, we do not do administration, so I don't know whether that's an issue or not, but anyway, I'm interested in your view.
Yeah, so I mean, I can only speak about LCP and the conclusion we came to with our own legal advice. So it was just in relation to scheme actuaries. Our sort of firm view is that scheme actuary is a joint data controller with trustees. In all of the other business areas, so corporate pensions consulting, pensions administration, we're data processors. So that's where we landed. I think other actuarial firms may have landed in a slightly different place, and I know different law firms have said slightly different things as well, but you've got to end up somewhere, and that's where we ended up. And our clients have agreed that in contracts with us as well, which I suppose reinforces the position that we have come to.
For taking your data process rather than data control?
I'm not sure I have much to add to what Chris has said. I mean, it comes down to what it is you are doing as a matter of fact, and what control you have over that, whether you are genuinely acting on the instruction of someone else. And certainly for a scheme actuary, my understanding is that you would be viewed to be a controller in terms of what you're doing, and a joint controller with the scheme. I suppose the role of the firm is the one where I think there is a bit more sort of variance in terms of what it is doing in terms of particular activities as to whether it might be a joint controller as well, or a controller in its own right, or a processor. And it certainly, in my experience, that seems to vary depending on the nature of the services being provided.
But taking the questioner's point here, would you agree with this, that it's not so much is there a legal justification, but I would have thought, and tell me if you disagree, the issue here is one that's essentially driven by the facts of what you are doing, who's calling the shots, if I can put it that way. So this is a very, very or fact-specific issue that you then apply the law to.
That's right, yeah.
I'm not whether that helps or not.
Obviously, we get data from our clients, and I don't feel I'm in control of it. I feel I'm processing it. In what sense am I controlling it?
Well, let me just challenge you, because I'm quoting from Martin, one of your slides out at the beginning, and remember this is law that isn't changing because of GDPR. Controller, the legal entity that determines the purpose and means of the processing of personal data. So if you're calling the shots, I suggest, about how you're going to process that personal data that's been sent to you, let's say, by your client, then that suggests to me that those particular facts, and it's obviously a very sketchy way of explaining it, would suggest you're a controller, not a process.
Yeah, no, I think there are 2 points in this. One is, for the scheme actually, you have specific duties.
I did tell you to turn your phones off.
There's a 2-minute warning for us tidying up.
It was my wife.
There are, I suppose, 2 points. One is, the scheme actually has specific functions that they are appointed to do as a person, and they are a legal entity who is distinct from the trustees. So that, I think, is where the scheme actually being a controller comes from, because it is duties on them as a person. They're not doing something on instruction. And then separately, if you are a professional advisor and you are subject to regulatory obligations, then you have obligations in relation to that data that sit aside from what you are doing on the instruction of your client. So, as a lawyer, we are viewed as being controllers and providing legal services, and we have obligations to the Law Society, with obligations in terms of doing AML checks on clients, all that kind of stuff. Our clients don't instruct us to do AML checks on them. We're doing that because we have a separate legal obligation. Yeah, we have to retain a client file to comply with our regulatory obligations for so many years, and that's not something we're doing in the instruction of our client. And if we were a processor, the client can say, well, delete your file because I don't want you holding it anymore because you're no longer processing it. So that is where some of these complications come from. It's the duties that are sitting on the individual or the firm in terms of the regulatory obligations, but also I think particularly for scheme actuaries, the role that they are carrying out as an individual, for which they are personally responsible.
And the fact that your client may purport to give you a particular set of instructions, don't bother with AML, is not going to absolve you as a professional person of those obligations.
Indeed,
to do that.
Yeah.
Okay. Well, ladies and gentlemen, sadly... Oh, right, we'll try and squeeze in one more question, the last question.
Thank you. We've taken advice on this. I think this issue of joint data controllers, I think for scheme actuaries, it's reasonably clear, but at least, even if it's not clear, then we've got very firm guidance from the Institute and faculty and so on, which I think makes it extremely difficult to take any other view than being joint data controller. But having read a bit on it and taken a bit of advice, I don't see a great distinction between when an individual is acting as scheme actuary and when an individual is acting as an employee of their firm, providing advice to trustees. So I don't know if we're unique in this, but the way in which we structure our contracts with trustees is that the formal statutory advice is provided by the scheme actuary as an individual, and everything else is provided by the firm. It might be normally delivered by that same individual, but the difference is it's provided by the firm as the entity. Now there's some of the tests for whether or not somebody is a joint data controller. One of the key considerations, as I understand it, is where that entity is subject to some overriding requirements, such as professional requirements, which apply to us whether we're scheme actuaries or whether we're acting as individual actuaries employed by the firm. We're subject to actuaries code, sometimes TASIs and so on, even if we're not acting as the formal scheme actuary on that particular day. So we've taken advice and kind of concluded that in most cases the firm, when we're providing actuarial specialist services, will be a joint data controller as well. So I'd be interested to hear your comments on that, please.
I think it's kind of, I suppose we've spoken about this in a couple of questions, that, I think it comes down to a question of fact, and the reasons that you have quoted for reaching those conclusions, I think they're entirely they sound sensible in terms of the conclusion you've reached based on what you are doing. Your firm is carrying out that processing, and as I explained, from my experience as a solicitor of what we're doing, we reach the same view. I don't think I have anything more to add other than that.
Do you accept the point that I guess the question poses, that certain aspects of the relationship, let's say with a pension scheme, could well be that you're just giving general advice, as it were, different to those statutory obligations, that is the responsibility of the firm, not the employee,
yes.
right?
Yeah.
I think there's some...
Yeah, so I very much agree with that it's the firm is being instructed to provide that general advice, but the scheme actuary is the one who's providing what the scheme actuary is doing, and I think it is entirely right to separate those out as being different services and therefore different controllers in relation to those. Okay.
Sorry, just one quick one. Yeah, just because I looked at the Institute of Faculty guidance quite closely when we were considering this, and just an observation really, if there is any intention to produce further guidance in some form for actuaries, and that's that document in a number of places kind of suggests or alludes to the fact that sometimes the firm will be a joint data controller as well, but it's not categoric, and that could be made more helpful if possible.
Well, yes, I understand the aspiration you make there. I think one of the reasons that we were not categoric in some respects in that regard is that the bundle of facts in a particular circumstance, and these circumstances are very variable, the sensitivity of those facts to be able to draw the conclusion was such that we weren't able to be more specific, more definite than we were in that last set of guidance. So I think that if we were reissuing guidance along those lines, because we're covering, such as I say, a myriad range of possibilities and alternatives, that we'd have to somehow frame the guidance to take account of that fact, or those facts, I should say. Okay? Now, the clock really has beaten, not least because I have to phone my wife back very quickly, but I need to do 2 or 3 things, if I may. First of all, to thank you for being with us tonight, and thank you in particular for all of your questions. You can stay behind for some refreshments, or to pursue some of these questions with panel members, you would be most welcome indeed. My final point is that I'd like to ask you, in joining me, to show our appreciation and thanks for the contributions and the work of our panel members this evening. Thank you both very much indeed.